My name is Spencer Wilkinson, and I'm a guardianship attorney at Jackson White Law. I wanted to talk to you today about some changes that are happening in Arizona with the way that guardianship and conservatorship processes work. Over the last year, the Arizona legislature has been working on a bill called SB1291 that proposed some changes to the statutes or to the laws that govern how guardianship and conservatorship processes happen. Governor Hobbs signed that bill into law on June 20th of 2023. And these changes that I talked about today in this video will go into effect by the end of this year. So it's important to note these changes and be prepared if you're considering a guardianship or a conservatorship for your loved one. The underlying purpose of these changes are to try to protect the constitutional rights for the alleged incapacitated persons in Arizona. You'll note that several of these changes increase the level of scrutiny and the difficulty for someone to be appointed as a guardian and conservator. The new law seeks to protect constitutional rights in the following ways. First, the petitioner, or the person who's asking the court to appoint a guardian or a conservator, must now send notice to interested persons by certified or registered mail. Second, the court-appointed attorney for the alleged incapacitated person must interview that person and tell them of the court processes and timelines, tell them of the responsibilities and duties that the guardian or conservator would have, as well as inform them of their right to a trial by jury. Third, a petition for appointment of a guardian or conservator must explicitly state whether the proposed ward, or the alleged incapacitated person, has a power of attorney, and if so, who the agent under that power of attorney is. The petition must also state whether or not the ward has a vested interest from any trust. Fourth, for the court to proceed with appointing a conservator with financial authority over an incapacitated person, the alleged incapacitated person must appear before the court or sign a declaration stating that they were aware of their right to appear and decided not to do so. Fifth, the new law creates and approves a new protective arrangement called a supportive decision-making arrangement. Under the new law, an alleged incapacitated person can sign over some authority to a supporter, to someone who is seeking their best interests, who can go to banks and hospitals and other institutions and request information to be given to them. They will then give that information to the alleged incapacitated person, who will make decisions for their own benefit and welfare. It is important to note that the supporter's ability and authority seems somewhat limited when compared to the authority that one can give under a power of attorney. Finally, when a court holds a hearing on a petition filed by either the incapacitated person or someone interested in contacting that alleged incapacitated person, the court must hold this hearing within 15 days. And the guardian who has withheld contact has the burden of saying whether or not the contact between the ward and the person requesting contact is detrimental to the ward's health, safety, or welfare. Now, this law was signed by the governor only a few days ago and is not yet in effect. However, by the time you watch this video, it could be in effect. There could be some unintended consequences that arise from this law, including confusion over duties between agents under a power of attorney and a supporter under a supportive decision-making agreement. I can also foresee there being a dramatic increase in the number of jury trials being handled by an already busy probate court system. I can also foresee increased costs associated with obtaining guardianship or conservatorship as a result of needing to go through a jury trial in order to obtain that authority. If you're looking into your options of how to help a loved one who's suffering from incapacity, and you may be considering a guardianship or a conservatorship arrangement, it's important for you to work with an attorney that understands the newest developments in the law as it relates to guardianships and conservatorships, and one that is aware of supported decision-making agreements so that you can understand and have full knowledge before you move forward to help protect your loved one.